You know what, and I'll stop here because I know, you know what I found when I do go on a website to try to get information or to communicate? I find all too often I can't even find a phone number. Maybe that's a separate issue. But they want you to do everything, through the computer, and to actually to communicate with a human being is very hard to do. There's very infrequently a phone number.
That's a good point, yes.
I guess what concerns me is you paint a picture that arbitration is good for consumers, good for business. If that were really the case, why is there then a need to have mandatory arbitration? Why couldn't it just be as an option presented as an option for the consumer to help resolve their dispute, since seem to say that they do, in your testimony say they do as well, if not better. Mm-hmm. Why the need to require this mandatory arbitration buried in the small print? I mean, there's been some studies showing the amount of time that it would have to take an individual to read all of those contracts that they've agreed to on signing up for various programs, and it's just more time than most of us have in a lifetime, let alone each time you go on to a particular contract.
But it still was probably a shorter period of time than if you were navigating the court system. But usually but to your question, usually there is an opportunity for a consumer to also utilize small claims court. That is usually an option that is there in the provisions. That's my understanding, again, from speaking with our members and doing a little bit of research.
And okay, I'm not sure that's true, and I'll have to go back and look at some of those things I've clicked. In terms of the members of the Business Council, so not only are they potentially defendants, sometimes they're also the individual that's the entity that's been wronged, and they have to proceed. Have you heard from any of the members of the Business Council as to their experience in having a mandatory arbitration clause and they're being precluded from the courts and their feeling about that?
No, I hadn't even thought of asking that question. That's a very good question. On that, I was really just looking at it from the other perspective. But that's a good question. I will go back with that.
Thank you. Is someone Steck?
Thank you. I do have sympathy for the position of business that the court system is too long and drawn out, and it might behoove us to create some simplified procedures for certain types of cases. I remember one I had where I was in front of a federal judge, and the judge said, "Mr. Steck, it was a construction case, your client should take $250,000 to settle this case." I said, "Judge, that's all very well and good, but with all the motions and all the procedures and all this and all that, it cost them $250,000 just to get here." So I do understand that problem, and I do think it's incumbent upon judges, which is extremely rare, to have some sensitivity to the costs of litigation, but upon us as legislators to perhaps come up with some alternative procedures that are not like every case is IBM against GE. So I sympathize with that. On the other hand, Chairwoman Weinstein made a very valid point, which is starting with insurance contracts, cell phone contracts, realistically, no one reads them, and practically no one can. You'd be up all night, you'd never get any sleep, and they're Byzantine. They're more Byzantine than the court system. So I think that is a serious problem. And then we have a point which Mr. Carpinello made, which is that the neutrality of the arbitrators is a problem. One of the oldest areas of arbitration is securities arbitration, and it's supposed to have one industry representative one neutral, and one consumer representative. But as a practical matter, they're all taken from the industry. So, you know, when you have a securities case that you can litigate in federal court, no one in their right mind who's representing a customer is going to want to go to arbitration because it's a stacked deck. So, you know, while I understand your cost concerns, there may be better ways of doing it than forcing people into contractual provisions that no one can read or understand, and also into a forum where in essence, the fox is guarding the hen house. So would you care to comment on that?
Well, only in the sense that I think for the most part, you're talking about small dollar amounts that you would be clogging up the court system with. And you have come up with an alternative dispute function here, which, in fact, the court administration, if you get on their website, they endorse it. Dispute resolution is one means, and it's right there on their website. So it is providing a way for people who have small claims to get through a process. If they're not happy with what the consumer rep said or their supervisor, they can go this route. And this route is providing them with a means to see some results. If they go into the court system, they're not going to be able to afford to hire a lawyer, pay the fees that are involved. It's very expensive to litigate, as you just said, sir. And with that, they don't have any other options. This is providing them with a means, and most of them within 5, 6, 7 months have resolution to their issue. So,
What would you think about if we were able to structure something under state law that would provide a similar inexpensive means for adjudicating these disputes, but not with onerous contract provisions and not with decision makers that are really not neutral?
I'm not sure what you're proposing then. And if we have a system in place that is working, maybe it's not perfect, but it's better than not having one. I'm not sure where else you would go with that. Maybe I'm not understanding your question. I apologize.
Thank you, Chairwoman Weinstein and Chairman Dinowitz, and Ms. Tully for your testimony. How do banks respond to the three-part series by the New York Times that asserted that roughly 2/3 of consumers contesting credit card fraud, fees, or costly loans receive no monetary awards in arbitration?
I don't have an answer to that. How did they respond to it?
Right. How do
That-
the banks respond?
That they have not received any monetary for
That roughly over 2/3 of the consumers have not.
I don't have an answer for
Okay.
that, but I'd certainly try and get you a response, Assemblywoman.
Thank you.
Okay, thank you very much.
Very much.
David Seligman, National Consumer Law Center.
Hi, how are you?
Good morning. Do you swear your testimony will be the truth?
I do. Chairman Dinowitz, Chairwoman Weinstein, first of all, thank you for the opportunity to speak today on behalf of the National Consumer Law Center and its low-income clients. I drafted the National Consumer Law Center's Model State Consumer and Employee Justice Enforcement Act, which includes 8 titles carefully drawn to avoid FAA preemption, so preemption under federal arbitration law, and strategies that states can use to address some of the harms of forced arbitration. I encourage you to take a look at that document, and I'm happy to answer any questions about it or any of its proposals. I wanted to, I'm not going to read from my remarks, but I wanted to address a few things that have come up in the prior testimony. So first, there's been a lot of talk about whether arbitration is fair. So Ms. Tully mentioned that in her opinion, arbitration agreements and what we call the Consumer Due Process Protocol of AAA ensure the fairness of an arbitration hearing. First off, I've got to point out something about that statement. It assumes that arbitration hearings are happening. They are not. So as a preliminary matter, before we even get to the point of addressing whether arbitration is fair, we have to recognize one important thing about arbitration. Arbitration suppresses claims. It is not about an alternative forum for resolving claims. It's about getting rid of claims entirely. So Chairman Dinowitz, you've mentioned a couple times, you've asked whether there's any empirical evidence out there, any data on these issues. I encourage you to take a look at the Consumer Financial Protection Bureau's March 2015 study on arbitration, forced arbitration in the consumer financial product marketplace. That study, mandated by the Dodd-Frank Act, found a startling dearth of claims brought in arbitration. I think from 2010 to 2013, there were only a couple hundred claims brought against credit card companies, banks, storefront payday lenders, huge numbers of institutions, and we're talking about just claims in the hundreds. So arbitration, it's not happening, right? That's the primary problem, the first issue. The other issue that I wanted to address right off the bat, and I think it's important for all of us to have this in our minds as we consider these issues, is Ms. Tully also mentioned that perhaps one of the reasons why so few claims are actually brought into arbitration is because we can think of it as customer service procedures are resolving these issues. People call up their bank and they resolve the problem before there's a need to go to court. And first of all, I based on my own personal experience, I would doubt that. But I think even before we presume that to be the case, it's important for us to remember the kinds of products and services that are covered by these provisions. We're talking about not only nursing home contracts, but low wage or employment contracts for low wage workers, enrollment agreements for for-profit colleges. Having worked with those clients, I know for a fact that none of them would be comfortable calling the merchant or the lender or their employer and resolving the issue that way. And even if they did, I seriously doubt that their for-profit college would actually give them their money back. Another issue as well, when it comes to class actions, I think that Mr. Carpinello is exactly right, that for the most part, this is really about class actions, right? And we see the proliferation of arbitration agreements coming right after the Supreme Court's 2011 decision in Concepcion, which had to do with class waivers. So I think that this is about class actions. Now, we've already talked a little bit about the small value claims and why class actions are important in addressing small value claims. I think that is a very important purpose of class actions. There's another one that we can't lose track of, and that affects low-income consumers, low-wage workers in particular. And that's that if you are, one important purpose of the class action is to allow one person to represent the interests of many others. So having worked, again, with former students of for-profit colleges, it's very hard. Many of them are very afraid to bring suit, feel like there's, that it's scary. They don't know much about the court system, and class actions allow for that. Within an arbitration scheme, for the most part, that's impossible. And so they cannot benefit from the class action device. So I wanted to mention, talk a little bit about another issue that I think it's important for us not to lose track of. We've already heard some discussion about our individual rights, the individual rights of consumers, and we're going to hear more about that. I think that's very important. I think that something else that you need to keep in mind is the way in which arbitration harms the interests of the state. The two things stick out. So first of all, in enforcing law, when you implement the New York law, when you seek to give it teeth, you don't put police officers, in every nursing home when someone signs their enrollment agreement. You don't put someone from the AG's office in every low-wage workplace. What you do is you give people a private cause of action. It's the only way to do it effectively, right? And that's the only way to do it efficiently, right? So a lot of the talk here is about how saving money, right? Well, imagine the resources that the arbitration system is forcing the state to expend to effectively enforce its laws, which are designed not only to protect consumers and employees, right, but which are also designed to maintain a fair marketplace for law-abiding businesses, right? I mean, their interests are also at stake here. So in enforcing your laws, you require a private cause of action. That's how the law works in America. I consider forced arbitration in this sense not only an impingement of individual rights, but really a way of subverting the democratic process, right? So if businesses have a problem with the class action device, or they have a problem with certain substantive, consumer and employment laws, their redress is in the state legislature. It's not in a contract of adhesion that creates a fiction, which no one agreed to. And then another way in which forced arbitration harms the interests of the state is in your inability to have an accurate picture of whether the entities with which you do business are following the law and therefore whether you are expending your resources in the most efficient manner possible. So when you spend however many millions of dollars in Medicaid on nursing homes, right, you depend on a private causes of action and dispute resolution in a public forum in order to ensure that those nursing homes are properly run. And without that, in a system of forced arbitration, you don't have an ability to make that kind of determination. So you'll hear much more about the individual rights of consumers and employees, but I also urge you to consider, frankly, the rights of the legislature as in its role in representing its constituents and ensuring that its laws are properly and effectively enforced. I'm happy to answer any questions that you may have, in particular about Federal Arbitration Act preemption, because I know that this is a tricky issue, but I think it's a very important one. I agree with Mr. Carpinello that it's important for us to be aggressive. I think that there are paths within the law to do something about arbitration at the state level, and I think it's important that New York take the lead on those issues.
So, in that regard, both, I guess, the two questions. Since you do have a national perspective, can you tell us about any legislative progress that may be happening in other states towards addressing the issue of mandatory arbitration clauses, and also the types of changes in the law that we could make that would impact on arbitration that wouldn't be preempted by the federal case law?
Sure. So I'll say that California in the 90s mostly, and at other points, had enacted some important statutes regarding arbitration. Some of those are preempted, but many not. And actually, the disclosure requirements that are before the Assembly now are modeled, it seems, on California, the California statute that does something similar. I'll say very quickly while I'm on that topic that California's disclosure requirements have been effective, but to a minimal extent, and something that's been missing from its statute that I strongly urge New York to consider is the inclusion of a private cause of action to enforce your disclosure requirements. The Attorney General in California has not been very effective at enforcing the disclosure requirements there, and so I think it's important to have some sort of private mechanism of doing so. But otherwise, since then, we're only now starting to see increased state and even local interest in municipal interest in arbitration. And I think that's in part because of increased attention to the issue, the New York Times article, and I should say increased dismay at the broadened scope of Federal Arbitration Act preemption and what it means. So Chicago right now, I know is considering an ordinance that would prevent the city from doing business with entities that use or enforce forced arbitration agreements in consumer and employment contracts. That is a broad measure. It escapes preemption under a doctrine that we call the market participant exception, which allows a government entity, when it's acting in its role as a market participant, to act as a market participant would. And this goes to the point that I was just making about the ways in which forced arbitration harms New York's interests in ensuring that its resources its limited resources are spent efficiently, and you have an interest in making sure that the companies with which you do business resolve their disputes publicly.
And so other than the sort of California from more than, you said the 90s, so
And I think
way
even
back.
before that, yeah.
So for several decades ago, the action in Chicago seems to be the only thing happening legislatively to sort of attack the issue?
There are. I can tell you that there are a number of states that are examining the issue now, and that are looking at some of the proposals. I know some of the proposals that the National Consumer Law Center has put forth, and other proposals. They're also, each state has its own arbitration act, right? And you mentioned that New York supplies when, for example, when the dispute doesn't involve interstate commerce, which is an exceedingly narrow, obviously, number of cases. But going back into the early 20th century, a number of states actually took actions at that stage that continue to escape preemption. So one very important measure that a lot of states enacted was prohibiting the arbitration of insurance disputes, insurance-related disputes. That is an exception to the general rule that you can't carve out certain kinds of disputes and say that they aren't subject to arbitration. And that's because the McCarran-Ferguson Act, federal statute, includes what we call a very legal wonky term, but it's called a reverse preemption provision, which allows states to regulate matters of insurance. So that's something that I also encourage New York to do, and something that the National Consumer Law Center has proposed.
And you heard Mr. Carpinella's number of his suggestions, either now or just post-hearing. If you could just comment on, from your experience, from your looking at these issues, if you think that we are at least, if they're doable, if they're, I know he said that some may be preempted, but we should test the waters to see if, in fact, they can work, and if there's been any attempt in other states to regulate in that direction.
Sure. So I think that the proposal that Mr. Carpinello was the most skeptical about, I'm probably even more skeptical about, and that's the idea of carving out certain kinds of disputes and saying that they can't be subject to arbitration, or saying that for example, in the nursing home context, raising the bar for mutual assent for arbitration agreements in particular, as opposed to different kinds of agreements. The Supreme Court addressed an issue very much like that one in a case called Doctors Associates v. Casarado, and held that you can't put arbitration agreements on different footing from other kinds of agreements. What you can do is say that those agreements, in the nursing home context, for example, you could say that material terms of a contract require a different kind of demonstration of assent. And there's a New Jersey case law that suggests that you can also say that certain kinds of waivers of statutory and constitutional rights need to be clear and conspicuous. So you can use that kind of have that kind of requirement for those types of terms. But I think it's going to be very difficult to say that certain kinds of disputes can't be arbitrated. I mean, the Supreme Court foreclosed really that avenue in the Marmot case. So I think, but I do think that it is important to be aggressive. I think that the market participant possibility is very viable, and I also think, and this is in the National Consumer Law Center's proposal as well, that there's a possibility of expanding key TAM provisions under state law to allow individuals to bring enforcement actions on behalf of the state, which California does for workers, and that kind of provision has been held not to be preempted. So that I think that's also a possibility. I mean, there are a number of others. The Model Act has 6 other proposals in addition to those 2 that I urge you to consider. There's Mr. Carpinello made another suggestion that I agree would not be preempted, but I think it's something that we should be very cautious about, actually, for policy reasons. And that's his he identified an issue which we call mutuality in the arbitration world, which is agreements or situations where a business uses the judicial process for its own affirmative litigation, but then seeks the protection of an arbitration provision. He talked in particular about debt collection actions in court. I think that is a problem, and it does actually illustrate one of the injustices and sort of absurdities of arbitration, right? But it's something that we should be very wary about. It was not too long ago that the National Arbitration Forum was effectively shut down because it was allowing debt collection actions to happen in arbitration, and the National Arbitration Forum had sort of systematic bias toward collectors, and I think that and we'll have other legal services attorneys here, but I think legal services attorneys will tell you that debt collection is an incredibly unfair process for consumers. It's made much less fair when it happens in arbitration than when it happens in court. So I would discourage the New York from and New York has already made great strides in making the process of debt collection more fair. I would discourage it from allowing or encouraging the arbitration of debt collection actions.
Could you give a short, brief sort of list of what you think is preempted, or is it not possible?
It's easier to say what I think is not preempted. I mean, if you gave me an example of something that...
If you just a list of what's not preempted, then.
Sure. So I think that the most aggressive option is the expansion of private attorney general provisions, key TAM provisions. Actions taken under your market participant authority are not preempted. State actions.
Participant meaning what?
I am of the opinion, and the National Consumer Law Center is of the opinion, that the New York State could by statute, stop doing business with entities that use or enforce forced arbitration agreements in consumer or employment disputes. New York could regulate contract formation issues, as we've discussed. But again, if it does, it would be preempted if it did so with regard to arbitration agreements in particular, and it should instead regulate material terms in contracts. New York would not be preempted if it codified sort of pre-existing principles of common law that exist under its unconscionability doctrines. So if it made clear that an arbitration clause is preempted if it includes a loser pays provision, for example, which are increasingly common in arbitration agreements, or if you lose if you're, you bring suit, then and in arbitration and you lose, then you have to pay the other side's costs. New York could, as I said, it could eliminate forced arbitration of issues related to insurance. New York could do a number of things related to arbitration providers as opposed to arbitration agreements. So we've talked about some of those disclosure requirements would certainly not be preempted. Rules relating to bias of arbitrators, which is California also has they've been found to not be preempted by federal law. Lastly, to give you an example of a kind of simple measure that would make a lot of difference, New York could could close off appeals from decisions denying the enforcement of arbitration clauses. So, for example, right now in New York, if you're a nursing home resident and you seek to sue your nursing home for some kind of negligence, and the trial court, based on specific factual findings, finds that you actually you didn't understand what was happening when you entered the nursing home, and that you therefore didn't meaningfully assent to the arbitration clause. Currently, the nursing home could appeal that decision immediately to an appellate court. And what that does is that actually slows down the process of resolving the dispute. Businesses obviously really like it because they can avoid having the dispute resolved, and it's a way to impose even higher costs on the consumer for even bringing the action. But that's a matter of state civil procedure, and something that the state could do something about. And they could say, no, if trial court makes a finding that you didn't meaningfully assent, then you go forward and resolve your dispute, and you can't appeal that until final judgment is entered.
Okay, thanks so much.
Thank you.